Hi, I'm Ray Welling, Editor-in-Chief of WorkplaceInfo, and I'm speaking with Julie Zettler, Senior Lecturer in Employment Law at Macquarie University, about the sweeping changes to the Privacy Act that take effect on the 12th of March. Why change the Privacy Act and the privacy principles? What was wrong with the old setup?
In order to understand that particular question, you need to recognise that the original Privacy Act was enacted in 1988 as a Commonwealth piece of legislation. The other thing you need to realise is that it is a core piece of privacy legislation. Since 1988, we have evolved in terms of information, and that evolution has mainly been related to technology and the transformational power of technology to digitise information, and also the global information economy, the push towards a global information economy. So the changes that have been happening, not just the recent changes, but over a number of years, really reflect the government trying to balance the types of privacy protection that individuals require with those of businesses and other organisations to be able to perform their legitimate business activities.
What are the key differences between the Australian privacy principles and the old information privacy principles and national privacy principles?
The new Australian privacy principles, which consist of 13 privacy principles, have been implemented because of the Australian Law Reform Commission's sort of review of Australian privacy law in 2007-2008, and the recommendations it made to the federal government about a unified set of privacy principles that would take Australia into the 21st century, would cover both public and private sector, and hopefully clarify the expectations and obligations of privacy in regard to information collection, usage, disclosure and handling.
So what will happen to companies who fall foul of the new Australian privacy principles?
The penalties are quite significant, but they really, try and relate to if it's a small business or a larger business operation in regards to that. They might be if it's a smaller business, but remember that small businesses are exempt under the Privacy Act at any rate. So I am talking, larger than just 2 people or 3 people businesses. So the types of penalties may in fact be something like $300,000 for a business breach, but that would have to be a really, really significant breach, up to $1.7 million for a corporation's breach. But again, it would have to be a very significant breach. The issue here is that the privacy legislation has enhanced the role of the Privacy Commissioner, or Information Commissioner as they're known now, and they take on an extended role within privacy protection, and they have been given sort of a role of being able to look at complaints and produce guidelines for businesses and organisations in this area. I don't think it is a matter of whipping anyone, sort of with the penalties, but I do think that if there are significant penalties, then hopefully organisation, businesses and that will start to take the issue of privacy seriously and security.
So Julie, what do employers need to do to embrace the new regime if they haven't already?
I believe that employers need to start to think about what the Privacy Act represents, or what privacy represents, and to look at it not just as obligations or compliance issues. I think you better understand this area if you can sort of see its development and its impact, or the sorts of impact that it will have on a society. So very basic things is educate yourself about what this is about, why it is so important that we protect privacy, whether it's individual privacy or corporate privacy or whatever, to try and develop a corporate culture that respects that privacy is a very important human right, and it does relate to things like trust, reputation, those sorts of issues that I'm sure most businesses want to keep going. So that's one thing, educate yourself. The other is there has been over the last couple of years a push to what's called privacy impact assessments, which are assessments that look at specific projects that maybe an organisation or a corporation is involved in. And what they do is that a PIA will tell the story of the project in relation to privacy and the impact that this project may have on privacy. And this then allows the organisation or the corporation to focus on what they can do to, sort of allay community concerns, or, sort of progress this further with the help of the community, all sorts of things like that. So they're two practical issues. Another, of course, is to smaller businesses. One big issue is that you need to look at, professionally really look at security, privacy and security software, and how you are organising that in your business. This is a big problem where there have been a number of security breaches in Australia through 2012 that has kind of led to lots and lots of, sort of business problems and things like this, and privacy issues. The other issue is that businesses now need to be aware of the new privacy amendment, privacy alerts legislation or act that will come into force also in March. This is about data notification breaches. It must know that there are mandatory reporting requirements in terms of any breaches. This comes from issues like Sony PlayStation, which in 2012 or something, where hackers obviously stole identity of thousands and thousands of customers from Sony. It wasn't so much the fact that the public were aware that this had happened, it was the fact that Sony did not contact individuals whose personal and sensitive detail had been taken for quite a long time after. So this is to try and get organisations, corporations, businesses to tell the Privacy Commissioner or the Information Commissioner when there is a breach, so it can be a proactive rather than a reactive consequence.